Yes, fixing this. Hold on back in.
Okay, there we are.
Yep, you're live. I can see you. But we need to mute it. Yep, you're live.
Is it this one right there between you and Spring Sound?
Yeah, I'm trying to.
There you go.
Sound this big, he's just gonna be this.
Okay, I think we should have it.
There. Hi, Jennifer.
Hi.
There, we can hear you. Make sure you speak up so we can hear you.
It's good.
No, a little bit more.
What about this? Better?
That's better. Project, yes, from the diaphragm. Go back to my computer. All right, it is 10:05 on March 16th. I will call the State Board of Elections to order. Would you all please rise for the national pledge of allegiance? I pledge allegiance to the flag of the United States of America, to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all. Roll call. Amy?
Good morning. Miss Ballard Croft,
Present.
Miss Cray,
Present.
Miss Genovese here, Miss McCrory,
Here.
Mr. Brett,
Here, thank you.
Miss Watson,
Here.
Vice Chair Turbin,
Here.
Chair Donahue.
Here. All right, could I have a motion for the minutes, approval of minutes of the February 18th meeting, please? It's been moved by member McCrory and
Second.
seconded by member Genovese. Would you call the roll, Amy?
Miss Ballard Croft,
Yes.
Miss Cray,
Yes.
Miss Genovese,
Yes.
Miss McCrory,
Yes.
Mr. Brett,
Yes.
Miss Watson,
Yes.
Vice Chair Turbin,
Yeah.
and Chair Donahue.
Yes,
Motion
All right.
passes.
thank you. I will just say for the record, we have Amy Kelly taking care of us today for Amy Calvin. So report of the general counsel, Marnie?
Hey, good morning, everybody. We have a relatively short agenda today, although a couple of the items are a longer script. So I appreciate everybody bearing with me. Our first case is the motion for reconsideration. Agenda item 2A1, SBE versus Citizens for Sarah Feigenholt, 25 AJ 18. I believe I saw Mr. Casper is there on behalf of the committee, KAFEER. I will read my recommendation and then turn the floor over to Mr. Casper.
Marty, if we could have a moment, Mr. Casper's outside.
Oh, okay.
He's walking in. Here he is.
Excellent.
Morning, everyone. Where do I go in this room? I've never been in this room. Hi, everyone.
You're right, Mike.
Green light, where is it?
Yeah, I'm sure there's a mysterious green light above you somewhere.
All right.
Excellent. I am going to read my recommendation and then Mr. Casper, you'll have your opportunity to speak.
Okay.
So here the committee is seeking reconsideration of a final order dated February 20th, 2026, imposing civil penalties totaling $770 for late disclosure of 2 A1s reported as received April 20th, 2025, each in the amount of $1,000. Rule 125.440D is what governs motions to reconsider. It reads in relevant part that the board may grant a motion to reconsider a final board order imposing a civil penalty for a delinquently filed report or report only if the board determines that the reasons the respondent failed to submit an appeal in a timely manner are outside the control of the respondent or otherwise extraordinary, and the basis for the appeal is meritorious. So here, the threshold question is whether the board determines that the reasons the respondent failed to submit an appeal in a timely manner are outside its control or otherwise extraordinary. So here, the committee claims that the candidate never received the initial assessment notice in order to file an appeal. Now, this committee's primary address is the candidate's home address, and the candidate has requested redaction of their home address because they are a public official. And it has therefore been redacted both publicly and in our CDS system. Now, when public officials request redaction of their home addresses, they were all advised to change their committee's main address to a non-redacted address so that the committee can be contacted. Now, this committee is one of only 11 committees in the state that failed to comply with those instructions to change the committee's address to a non-redacted address. So in this instance, although in addition to the redacted primary address, the committee has two other addresses on record, those of the committee's two co-chairs. Now, I've been advised by Mr. Newman, who's our Director of Campaign Disclosure, that it is possible that the candidate's home address might not have received an assessment notice here due to the redaction in the CDS system, but the assessment would have been sent to the two other addresses on file of the committee's co-chairs, one of whom is the treasurer. The committee's affidavit submitted is silent as to whether the co-chairs of the committee received the assessment notice. Now, under these circumstances, I don't think the failure to submit a timely appeal was necessarily outside the control of the respondent or otherwise extraordinary because it was sent to multiple addresses. So I recommend denying the motion for those reasons. That said, it does appear a timely appeal in this matter would have been meritorious. Although the committee reported the contribution as received on April 20th, 2025, which was the date on one of the checks received, the committee has provided banking documents showing the actual date of deposit is May 12th, 2025, which is the proper reporting date under Election Code Section 9-10D, and which means that the disclosure would have been timely. Now, if the board does determine that the failure to timely appeal was outside the control of the respondent or otherwise extraordinary, then the appeal can be granted. Additionally, this committee has not amended its quarterly reports for the second quarter of 2025, or at least it hadn't as of a few days ago, to correct the dates of the contribution to show the May 12th, 2025 date of deposit, and I recommend that they do so.
All right, Mr. Casper.
Thank you. Good morning, everyone. Thanks for hearing our motion. I believe that Ms. Malowitz has correctly identified the position that we're taking. Our position is simply you can't appeal something you don't know about. And the committee, we submitted an affidavit from the candidate. The committee's been registered at her home for 30-some years. The redaction she did last summer, and the first communication I think that the board tried to make with her came after that, and the letter never arrived. The final order showed up at her house, though, by the U.S. Postal Service. So I think it was just an instance of the Postal Service not delivering the original notice. Now, why we're still in the business of sending these things by U.S. Post without any sort of return, certified mail, whatever, I don't know. That's sort of beyond my merit. But you can't appeal something you don't know about. If this business about having to change your address is being advised, not required, there's certainly no statute that I'm aware of that required someone to change their address. My client wasn't made aware of that either. They certainly would have mentioned that to me if they had been advised to do that. So this is just an instance where to get to the merits of the appeal, this involves one of those Act Blue contributions. And a person makes a contribution to a committee through one of these services like Act Blue.
Are you in this meeting or no?
I hope I'm in this meeting.
No, who's Kyle Weber?
He's later on the agenda. He accidentally came off.
All right. Go ahead, Mr. Casper. Sorry for the interruption.
So to the merits, and when you make a contribution to Act Blue, you make a contribution, say on Monday, today, the 16th of March. Act Blue holds the contributions and then periodically sends you a check that encompasses my contribution and others. And so maybe they send that out on Friday, which Friday would be what, the 20th? The committee receives the check from Act Blue, say next Monday, the 23rd, and deposits the check on the 23rd. The committee should report that contribution as being received on the 23rd, because that's the day they deposit the check from Act. That's what the law says. This committee reported the contribution as being received today, the day Act Blue got it. And I submitted, as Ms. Mello had said, I submitted the evidence to support that. And so that if they haven't amended the complaint, or if they haven't amended the quarterly report to reflect that yet, then they weren't listening to what I told them to do when they first called me a week ago. So that I have advised them to do that, and they will do that. So, you know, as I said, getting to whether or not this appeal should be granted, you know, Senator Feigenholz has used her home address for 30-some years. This is the first time she ever failed to get a communication from the board. That is largely because she doesn't get very many communications from the board. I don't think, Tom, she's ever had a violation in 30 years. And so this is the first one. So for that reason, we ask that you grant the motion to reconsider and grant the appeal. Or I'm happy if you want to remand it for a hearing officer, or we could have a hearing on this. I'm happy.
Has the address been corrected or made in such a way that, you know, we won't have this happen in the future?
Yeah, you know, that's a good question. Not yet. And the reason that hasn't happened yet is I had no idea that the board was advising committees to change their addresses when they did a redaction. Neither did my client. But now that we know that, we will, sure.
Okay. Then,
Madam President,
She did get the final order in the mail, which is weird.
Madam President, if I may, please.
no, I'm not recognizing people that are not on camera. Is there any further discussion?
Yeah.
You're not recognizing people that aren't on camera.
Yes, ma'am, and I think you have been notified of that. I don't,
No, I have not been notified that you were not recognizing people that weren't on camera. So I'm advising you today that I have not been told that you were not recognizing people that were not on camera.
then for the future, you have been. So, Madam Member Watson.
I have a question with respect to the final order and the certificate of service. The certificate of service signed by Tom Newman said that says, quote, "The undersigned of the Illinois State Board of Election hereby certifies that the foregoing order was served upon each of the addresses listed by enclosing the same in an envelope and depositing the same in the U.S. Mailbox in Springfield. I have reviewed the final order, which is in my packet, and I don't see any addresses, Mr. Newman, in the final order.
That's correct, Member Watson. It was redacted in the packet because it is a lawmaker who has requested redaction, so we can't make it public. So there was an actual address on the final order, but it's been redacted for this packet.
I can actually see a little bit of it underneath where it says Citizens of Sarah Feigenholz, but you can see it's redacted out.
There are.
So you're saying that all of the addresses were requested to be redacted? I understood from reviewing the letter that only the Miss Feigenholtz address was redacted.
Did her treasurer not receive the letter? Mr. Casper?
We don't know
There aren't any addresses listed in the order.
Now,
Correct. The final orders just go to the main committee address. So in this case, it would have just gone to Senator Feigenholtz's home address.
and there's no dispute that Senator Feigenholtz received this order.
Correct.
She received the final order, but I'm talking about the assessment letter. The assessment letter.
Right, but the certificate of service is for the final order, not for the assessment letter.
Thank you. Is there an assessment letter that was ever sent to Miss Feigenholtz?
So
Yes.
it was sent to Senator Feigenholtz as well as to the two co-chairs.
Do you have a certificate of service of that?
Tom Newman is shaking his head no.
Member Turbin?
I feel the appeal should be granted because this person has had 30 years of service with never being late or anything else. And I think sometimes we need to take their word that they didn't receive it and that we need to grant the appeal. Thank you.
Member Genovese?
I just thought from your recommendation earlier that you said she did not receive the assessment order. It only went to the other two.
She did not receive the initial assessment letter from which she would have appealed,
Right.
but then the board entered a final order and she did receive the final order.
Okay, because you just said earlier that all three of them received the assessment order, or did they all three receive the?
They
final
all
order?
three received the assessment letter, but only the main address received the final order, which was sent by certified mail and which was received by Senator Feigenholtz, according to Mr. Casper.
Now you're saying that the senator did receive,
They were mailed.
they were mailed.
They were mailed to the
Okay.
senator. The
Received.
assessment notice
Yeah, that was a bad.
was mailed to all three. The final order was only mailed to the senator.
Yeah, gotcha.
And just for clarification, there's no. Of that mailing.
We didn't hear that.
We're not hearing you, Ballard, Member Ballard Croft?
Can you hear me?
Yes.
Yeah.
No, I can't hear you, Jennifer.
Okay, I'm eating the mic. I think that's good. All right, I just want to clarify that we're saying that the assessment letter was mailed to 3 addresses. However, I want to clarify, there is not a certificate of service confirming that, correct?
That's correct, based on what Mr. Newman has represented.
Thank you.
And just for clarification from my client's perspective, I did attach to the motion an affidavit from Senator Feigenholtz stating that she did not in fact receive the assessment letter.
Oh.
So-
Member McCrory,
Some questions about whether or not
can you hear?
we're notified.
Here.
I still have questions as to whether or not her co-chairs have been notified. So therefore, I would consider the motion to reconsider, but I would rather send this to public hearing to hash all of the questions that we all have on this out.
So actually, that's not the standard under a motion to reconsider. Under a motion to reconsider, under the rule, they just have to show that the appeal itself was meritorious and that the circumstances were beyond the control of the committee or otherwise extraordinary. So there's no provision for a remand to determine any factual circumstances
There
leading
could
up to
be.
that.
It should be.
So, Madam President, we don't have any proof that the assessment letter was ever received by anyone. Is that correct?
That's correct, but the burden here is on the committee. So it's the committee who ought to be showing that they did not receive it. Now, of
But
course.
we
the
don't
Senate-
have any proof. The board cannot prove that they sent out any assessment letters. Am I correct on that point? I just want the record to be clear.
There's no written proof, correct?
The standard of review is not for us to prove that we sent the letter. The standard of review is for them to prove that they did not receive it. That's what the statute says.
And while the senator did not receive it, we do not know if the co-chairs received it.
Well, if the Senate
Member
certified she didn't receive it, she's the boss. So I think that should take some weight in what we're doing here for a decision.
I have a question, Madam Chair.
Member Cray?
Is there any way we could separate this out into two motions?
Sure.
Okay, so one saying, we recognize they somehow saying they didn't get it, so nothing, they get their hands slapped for that. But on the second one, can we say we are going to not charge them with a fine? Does that make sense?
It does. So both elements are required to pass, though, in order to grant the appeal.
Okay,
But that doesn't mean we can't vote on them separately because, you know, people may have different opinions on the two factors.
Mr. Casper, you said at the end of your comments, something about if we saw fit to go to a public hearing, what is your feeling about? I mean, I'm not inclined to. I mean, I kind of feel like this happens and, you know, it's first time in 30 years. So, but you said something there at the end that you,
That's what I was asking.
Yeah.
I've been told that we can't do that.
Yeah.
Right. So here, it's a lower burden on the committee. The committee just has to show, you know, that it was excusable to not have filed the appeal on time. And then second, that the appeal is meritorious. So here, it's undisputed that the appeal is meritorious. So the question here is just this narrow question of whether we're going to accept the committee's explanation as to why it did not timely appeal. And its explanation for that is
they
that
did get it.
the senator did not receive the letter.
So I do
Madam
kind
Chair?
of,
I'll speak.
Madam
just
Chair?
1 second. I kind of have a question of where, about the other two. They are the treasurer and I know she's the candidate, and whatever, but it's the treasurer and the committee that kind of run the things. But Member Brett?
Thank you. Can you hear me okay? Is my voice
Yeah,
not too
we
much?
can.
Okay. All right.
I'm sorry, Member Brett, I can't hear you.
All right. Well, I will speak up. I would like to move that we grant the request for reconsideration and grant the appeal on the basis that it would have been meritorious if timely filed. And I have been persuaded by Mr. Casper's representations as to why the appeal was not filed. So I would like to make that motion.
Second the motion.
Well,
Unless Mr. Turbin already made that motion and I'm seconding
no,
it.
I'm going
Thank
to, motions made by Member Brett. It's been seconded by Member Turbin. Roll call, please.
Ms. Bellercroft,
Yes.
Ms. Craig,
yes.
Ms. Genovese.
Yes.
Ms. McCrory.
Yes.
Mr. Brett,
Yes.
Ms. Watson,
Yes.
Vice Chair Turbin,
Yes.
Chair Donahue,
Yes.
motion passed.
Thank you all. Sorry for the trouble.
Now, noted your green bow tie, Mr. Casper.
Thank you. Yeah, right. I got one more day of this.
Yes, sir. All right. Marnie, next up, 2A2.
Yes, 2A2, this is our longest case for the day. It's DeVore versus Citizens for Hammond, 25 CD 45. We have Mr. Fogarty here on behalf of Citizens for Hammond. And is Mr. DeVore present?
Is Mr. DeVore in Chicago? All right. Note that he is not present.
Bernadette is noting that there are 3 people on Zoom, and do you want us to check who they are?
Those are the names.
Yes. Who is Mr. Weber? Kyle Weber?
Kyle Weber is from ES&S Voting Systems, so we know that he's okay and he's here for
Got
a
it.
later matter, but I'm curious who the 402 is.
Do you want me to admit them and ask, or
Is that okay, Madam Chair?
Yes, please.
ES&S as well? What about Becky? Those are all ES&S, okay.
Yes.
They're all
So those are all
ES&S.
ES&S.
Okay, no problem. Marnie, continue.
So Mr. DeVore is not here. But I can read my recommendation and we can go from there.
Number to mute. Thank you.
Jennifer, sorry, you're breaking up.
It's taken care of. I was just asking them to mute.
Excellent.
Eat the mic, my dear. That's good. All right, Marnie.
So, I mean, theoretically, when a complainant does not show up, occasionally we will dismiss for want of prosecution. But I mean, there is a snowstorm, so it's in the, within the discretion of the board. So I'll read my recommendation. The committee is seeking reconsideration of the board's order last month, which found this complaint was filed on justifiable grounds as to potential violations of section 9-8.10A11, which prohibits payments to a candidate or public official or their family member other than for services rendered, and section 9-11A 12 and 13, which requires particular disclosures for itemizable expenditures exceeding $150. A public hearing was ordered by the board last month. Now, prior to the board hearing, the committee amended its quarterly reports for a 2-year period to identify the end vendor that received payments exceeding $150, rather than the prior reporting, which showed reimbursement to the candidate only. So this way, we could see to whom the candidate had given the funds. Now, these amendments show that some, but not all reimbursements to the candidate in an amount of $150 or less were in fact for expenditures exceeding $150 and which should have been itemized in the committee's original reporting. Now, the committee did not challenge the justifiable grounds finding, but rather is challenging the order of a public hearing and whether a public hearing is necessary. So the relevant portion of Rule 125.440D with regards to a motion for reconsideration outside the appeal context provides that a board can grant a motion to reconsider a final board order if reconsideration is necessary to correct an error of fact or law. Now, the board's rules do not define the term final board order or any similar term. However, Article 9 adopts the administrative review law for any party adversely affected by a judgment of the board to seek judicial review. And that's under section 9-22 of the Election Code. The administrative review law defines a final administrative decision subject to judicial review as, quote, any decision, order, or determination of any administrative agency rendered in a particular case, which affects the legal rights, duties, or privileges of parties, and which terminates the proceedings before the administrative agency. That is 735 ILCS 5/3-101. Now, no final decision has been rendered in this matter. Rather, the board referred the matter to public hearing and has not terminated proceedings before the agency. Therefore, I'm recommending that Rule 125.440 is inapplicable to the non-final order challenged here, and that's a basis to deny the motion to reconsider. Now, in arguing that the board made an error by ordering a public hearing, the committee points to Rule 125.262A, which says that the board will order a public hearing if the board determines that the complaint was filed on justifiable grounds and if the respondent, number 1, disputes that it violated Article 9, 2, is unwilling to take action necessary to correct any violation, or 3, is unwilling to refrain from the conduct giving rise to the violation. The committee argues that the committee did not dispute it violated Article 9 and it willingly took action to correct any violation, and that it will willingly refrain from the conduct giving rise to the violation. So therefore, the respondent argues the board should not have ordered this matter to proceed to a public hearing. Now, the complainant filed a response to the motion to reconsider, which argues that the board is not required to take the respondent's amended reports at face value in determining the committee's willingness to take action necessary to correct any violation, and that the board already agreed with this in ordering this complaint to public hearing. The complainant also expresses doubts about the accuracy of the amendment. Complainant says at last month's meeting, the board asked if the committee's amended filings included documentary evidence and support, and the answer to that question is no, as Article 9 does not require a committee to attach any receipts or other documentation in its quarterly reports. Complainant argues payments made to the candidate can only be determined to have been legitimate non-itemized expenses after reviewing the underlying documents, and that has not happened here. Although I appreciate the committee's proactive effort to amend its reports, I agree with complainant's point that there remains questions of fact as to whether the committee has in fact corrected all violations. Additionally, although the respondent did not dispute that justifiable grounds existed, I don't understand the respondent's position here to be that they did in fact violate section 9-8.10A11, which prohibits payments to a candidate except for services rendered. Rather, the committee's position seems to be that there was some evidence permitting a justifiable grounds determination on that statute. And I understand the committee's defense to be that these were permissible reimbursements of actual expenses paid and not improper payments to a candidate prohibited by section 9-8.10. Now, the main goal of a public hearing from my perspective is to figure out whether there were any improper payments in violation of section 9-8.10, not exclusively any failure to itemize expenses of $150 or more in violation of section 9-11. Additionally, violations of section 9-8.10 are subject to fines under the election code. Under subsection B, the board may levy a fine on any person who knowingly makes expenditures in violation of this section and on any person who knowingly makes a malicious and false accusation of a violation under this section. The board may act under this subsection only upon the affirmative vote of at least 5 members. The fine shall not exceed $500 for each expenditure of $500 or less, and shall not exceed the amount of the expenditure plus $500 for each expenditure greater than $500. So here it would not be possible to calculate any applicable fine without a determination of whether, when, and in what amount section 9-8.10 was violated. So here I do not see how the respondent has demonstrated an error of fact or law by the board under Rule 125.440D. And so it is my recommendation that the motion to reconsider be denied.
Mr. Fogarty.
Yes, I'll start with the jurisdictional question. I would note that the board's rules of procedure do contemplate motions brought, and I think that's 125.110. They're not enunciated as any particular type of motion, but I think it's perfectly appropriate, especially at this juncture, to bring a motion to reconsider whether or not this is a final order that sent this matter to a public hearing or not. I would also contend that for all intents and purposes, that order to send this to a public hearing was a final order that did aggrieve a committee, and that regardless, a motion to reconsider is should be well taken procedurally. I think to not allow a party to bring the matter to you in good faith at this juncture somehow would be kind of an absurd result of our. So I hope you'll hear it. As to the merits, I spoke a lot about this at our last meeting. Looking at the criteria by which this board may send something to a public hearing, there are 3 criteria, and our contention is that this committee has satisfied those criteria. We do not dispute that there was a violation of Article 9. We absolutely were willing and did take corrective action, and we are stated that we're going to refrain from the conduct giving rise to the violation in the future. The conduct that we are talking about is simply a candidate who paid for items herself and then was reimbursed by her committee for those items. Low ticket items, for the most part. There were some items that were over $150, and those should have been disclosed, and they are now disclosed. Small ticket items that were erroneously booked as reimbursement for non-itemizable purchases. We concede that that was an incorrect procedure. That was an incorrect way to describe these items. But those matters have been corrected. I have to take it with the idea that these are improper payments to the candidate herself. Not any of the items have ever been described as anything other than reimbursements. So the idea that they are payments for something, it is purely speculation. And yes, it was sort of thrown in to this complaint, but these were reimbursements from step 1 to step 100. We have now corrected 2 years of D2s, and our contention is that I feel as if I should have brought this standard to you when I was arguing last month. We have adhered to this standard, and we believe, respectfully, deference that a misapplication of the law was made, notwithstanding our general counsel's arguments to the contrary. So we would ask for a yes on this motion to reconsider. And in the alternative, I would ask that this be dismissed for wanton prosecution. Snowing up here as well. I am here. The complainant is not. That is, they can refile, they can do whatever they would like. Thank you.
Is there discussion?
Just confirming.
Member McCrory?
Was the complainant in Chicago or Springfield last time?
I believe Springfield. Yes.
Thank you.
And no one's received any calls or text messages from the complainant.
Has there been any calls or questions from Jennifer asked?
Tom is shaking his head no.
Member Craig?
Actually,
Hold on, we have something in Chicago.
I received an email at 10:34 saying, gentlemen, I had a tree come down on my house and I cannot get to Springfield personally. Can I attend remote?
Did you all hear that?
Not well.
Not well. Andy, go closer to and speak a little slower.
I received a email at 10:34 saying, gentlemen, I had a tree down on my house and I cannot get to Springfield personally. Can I attend remotely?
Oh, well,
I mean, the meeting had started 10:34. When was this? Today? This morning?
Yes.
So just a couple minutes ago.
yes.
And I received a call from the complainant at 10:12.
Member Craig?
I would like to make a motion to dismiss for want of prosecution.
Motion has been made by member Craig. Is there a second?
I'll second it.
It's been moved by member Cray, seconded by member McCrory. Amy, roll call, please.
Ms. Fowler-Croft,
Yes.
Ms. Cray,
Yes.
Ms. Genovese,
Yes.
Ms. McCrory,
Yes.
Mr. Verrett,
You're on mute.
Yes.
Ms. Watson,
Present.
Vice Chair Turbin,
Yes.
Chair Donahue.
Abstain.
Motion passed.
Thank you. Marnie, to continue settlement offers, please.
Yes, we have two settlement offers and we have an appearance on the first. Agenda item 2A3, SBE versus Will County Democratic Central Committee, 24 AD 12. We have an appearance on file from attorney Michael Moustis, Moustis. And is it Moustis or Mustis?
Eustace, it's Matt.
Mustis.
Eustace.
Sorry about that. I will work on remembering that in the future. So I will read my recommendation and then Attorney Mustis will have an opportunity to address the board. So the committee is offering $4,500, which is 50%, to settle $9,000 in fines for late filing of 4 A1s during the fourth quarter of 2024. The offer meets the 50% benchmark and the receipts ratio at 54.72%, but it falls short on the balance ratio, which is only 31.55%. The committee is not low dollar and has an average ending balance of $28,530.57 and a most recently reported balance of $44,667.31. The board previously rejected an identical offer by this committee in October 2025. Here, the committee asked the board to consider that the contributions were deposited by the committee's former chair without notifying the treasurer. Since then, the committee has appointed a new chairman and a new policy requiring the treasurer, who is a CPA, to make all deposits and to file all committee reports personally. The committee also argues the filings were no more than 55 days late, which the committee says is not an excessively long period of time. Now, due primarily to the committee's low balance ratio, here I recommend rejecting the offer and weighing the settlement factors of Rule 125.450.
Mr. Mustis?
Good morning, Chair Donahue, members of the State Board of Elections. My name is Matt Eustace. I'm attorney. I represent the committee.
Could you speak up,
Speak
sir?
a little direct. There you,
The-
yeah, use the mic. That's the best.
Good morning.
There you go.
I represent the committee, and as the general counsel stated, it was an inadvertent.
Put the mic up to your
Hold
mouth.
it to your mouth.
The error was inadvertent. As the general counsel stated, the chairman of the committee made deposits in the committee's bank account, and the treasurer didn't get a notification of it. So he wasn't aware that deposits had been made. When he was preparing to file the next quarterly report, he learned that the contributions had been deposited and they were disclosed. It was inadvertent. The settlement offers is 50% of the fines that are outstanding. And the amount does exceed the 50% threshold for the ratio of fines to average receipts. I think most importantly, they've taken measures to make sure that this doesn't happen again. They've implemented a policy where the treasurer is the only person who makes deposits into their bank account. And that same person is the person who prepares all the committee's reports. So based on that, I would ask that you consider those things and accept the $4,500.
Thank you, Mr. Moses. Is there questions? I would say, what would be the amount if it met all our criteria? It meets two of them, it doesn't meet the third one.
So it cannot, there's no way to make it meet the criteria. The ratio is only 31.55%. That's the balance ratio, and it's because the committee has a lot of money.
Okay. Is there a motion?
I make a motion, we accept the 50% offer that is offered.
Is there a second?
What was the motion?
The motion was to accept the offer.
4.72%.
Okay, what is the offer?
$4,500.
$4,500. Is there a second?
Second.
It's been moved by member Turbin, seconded by member Genovese. Roll call, Amy.
Ms. Ballard Croft,
Yes.
Ms. Craig?
Yes.
Ms. Genovese?
Yes.
Ms. McCrory?
Yes.
Mr. Brett?
Yes.
Ms. Watson?
Yes.
Vice Chair Turbin?
Yes.
And Chair Donahue?
Yes.
Motion passed.
Marnie?
Next, we have a settlement offer for agenda item 2A4, SBE versus Friends of Mark Bond, 25 AD 55. Is anyone there on behalf of the committee in Chicago?
Jennifer? Anybody up there?
There's someone here.
And no one is here either. The recommendation is to accept the offer as it's favorable under the board settlement factors.
Do I have a motion?
So moved.
It's been moved by member Turbin, seconded by member Cray. Roll call, Amy.
Ms. Ballard Croft?
Yes.
Ms. Craig?
Yes.
Ms. Genovese?
Yes.
Ms. McCrory?
Yes.
Mr. Brett?
Yes.
Ms. Watson?
Yes.
Vice Chair Turbin?
Yes.
Chair Donahue?
Yes.
Motion passed.
Next, we have an appeal in which the hearing officer recommends granting. It's agenda item 2A5, SBE versus Arab American Democratic Club, 25 AM 101, pardon me. Is anyone up there in Chicago on behalf of the committee?
No.
And there is no one here in Springfield. The recommendation here is to grant the appeal. The A1s were mistakenly reported based on the date on the check rather than the date of deposit. And the committee has already updated its quarterly reports. So the recommendation is grant the appeal.
Is there a motion?
So moved.
So
It's
moved.
been moved by member Cray, seconded by member Brett. Roll call, Amy.
Ms. Ballard Croft?
Yes.
Ms. Craig?
Yes.
Ms. Genovese?
Yes.
Ms. McCrory?
Yes.
Mr. Brett?
Yes.
Ms. Watson?
Yes.
Vice Chair Turbin?
Yes.
And Chair Donahue?
Yes.
Motion passed.
Moving on to other campaign disclosure items. A6, consideration of random audit selection percentage. You have a memorandum in your packet from Tom Newman. Section 9-13C of the election code requires that annually the board can order up to 3% of committees to perform an audit of their financial records. The committees are selected at random using software, so there's no discretion used in selecting which committees are audited. A political committee selected to conduct an audit is only required to conduct the audit if it was required to file at least one quarterly report during the period to be covered by the audit and either has a fund balance of $10,000 or more at the close of the most recent reporting period, has an average closing fund balance of $10,000 or more on quarterly reports during the 2-year period to be covered by the audit, or average total receipts of $10,000 or more on quarterly reports occurring during the 2-year period. However, if a committee owes fines, the committee does still have to perform the audit, even if it has less than $10,000. Now, the Division of Campaign Disclosure recommends selecting 3% as the number of committees to select for the random audit, as it has done for the past few years, and that is the maximum. Just FYI, last year, there were 7 committees who were required to complete their audits, but did not do so. And all 7 of those committees were referred to their state's attorneys. Now, this does require a board motion to set the audit percentage at 3%.
Do we have any knowledge of the follow-up with the state's attorneys? Is there any repercussion if they just blow us off?
They're not required to report back to us. And
Generally, it varies from county to county. Sometimes we do hear back from a county. Typically, their involvement is limited to contacting the committee, putting a little extra twist to the arm and getting them to file the audit, even if it's very late. I'm not aware of any actual penalties that have ever been imposed as a result of one of our referrals for this.
Member Turbin?
Did the so-called arm twisting get any of that done then?
In some cases, it's helped. In other cases, it has not.
Madam Chair,
Member Cray?
I'll make the motion for 3% for this year.
It's been moved by member Cray. Is it seconded? Seconded by member McCrory. Roll call, Amy.
Ms. Ballard Croft,
Yes.
Ms. Cray,
Yes.
Ms. Genovese,
Yes.
Ms. McCrory,
Yes.
Mr. Brett,
Yes.
Ms. Watson,
Yes.
Vice Chair Turbin,
Yes.
and Chair Donahue.
Yes.
Motion passed.
And I would ask Tom, if I may, that the board be notified of the 7 committees that did not report. All of us. All right, next up, Marnie.
Next up is an informational memo on the good people who paid their civil penalty assessment, and that's item A7. So next would be complaints following closed preliminary hearing. Agenda item A8 is being bumped to next month. So we have A9 and A10. Now, if we want to hear those complaints, they would be in closed preliminary hearing. However, we've established Mr. DeVore is the complainant on both of those and is not present, and contacted the board at 10:36 a.m. to request to participate remotely due to a tree falling on his house. So there's an option to dismiss for want of prosecution. There's an option to postpone this till next month, or there's an option to go into closed preliminary hearing and argue the case. Now, Mr. Fogarty is here on behalf of both committees. Normally, we would ask if it's Mr. Fogarty's preference that we proceed in a particular manner.
Yes, and thank you for hearing me. Mr. DeVore did email stating that he would be fine just standing on the recommendation of the well, you know what, let me reread his email. I would have no problem just taking this over under the circumstances to the next meeting. Or if you'll give me a moment.
Marty, both of these were not filed on justifiable grounds, correct?
That's the recommendation of myself and the hearing officer, is that they were not filed on justifiable grounds under section 9-25.
So what is the motion? What is the board's preference?
I think we're giving Mr. Fogarty a
Oh,
moment.
Mr. Fogarty?
He's gonna read an email from Mr. DeVore.
He just asks if he can appear remote.
So nothing more than the last, just a request to appear remotely.
Right.
And I guess that's a fourth option, is to allow him to appear remotely.
How,
If we want to set a precedent.
I apologize.
The recommendations.
I'll make a motion.
Gary's trying to say something.
He sent a few emails I had to dig out. He says, I'm okay with accepting the recommendations on DeWitt and Bertelsmann, is remote possible on it. So I'm whatever the board would like to do with that. I'm fine.
Thank you, Mr. Fogarty, but I recognize the problem, but I don't want to set any precedent for this in the future. And considering the recommendations, I would take a motion from Member Cray to accept the recommendations on 2A9 and 2A10, the recommendations of the general counsel and the hearing officer. That's your motion. Do I have a second?
Second.
It's been moved and seconded by Member Turbin. Amy, roll call, please.
Ms. Ballard Croft,
Yes.
Ms. Cray,
Yes.
Ms. Genovese,
Yes.
Ms. McCrory,
Yes.
Mr. Brett,
Yes.
Ms. Watson,
Yes.
Vice Chair Turbin,
Yes.
and Chair Donahue.
Yes.
Motion passed.
Madam
Thank you,
Chair.
Mr. Fogarty.
Madam Chair.
Member Brett?
I have a question for the general counsel. What is the standard after something has been dismissed for want of prosecution for it to come back again?
There is a motion to reconsider a final order. Because, you know, I guess if that came back, I could argue that the order isn't final, but I don't think I've ever actually done that. Normally, when we dismiss for want of prosecution, the person goes away and does not come back.
Thank you, Marty. All right.
Or actually, you know what, I would recommend that that a motion to reconsider be considered because it is a final order under our rules and that it disposes of the case. So I think that would give a committee an opportunity to come back should that ever happen.
The litigator in me always wants to be lenient. Okay, thank you.
Very good.
Thank you, Mr. Rett. All right, we didn't go into executive session, so we won't arise. We've made our business public. So, Marnie, thank you. Is there anything else you need to deal with?
That is my relatively short report this morning after my 4-hour report last time.
That's very pleasant. Thank you.
Thank you.
All right, next up is the report of the executive director. Bernadette?
Good morning, everyone. The first item are on my report are preparations for March 17th, 2026 general primary election. So that is tomorrow. It is here. Just generally wanted to say early voting has been proceeding across the state with limited issues. I say limited, most of the issues that we've heard about that have been reported to us have been ballot issues at the jurisdictional level, obviously the judicial review cases that were hanging up, finalization of ballots, but nothing has been reported to us that has been a major issue and especially statewide.
Let me stop you real quick and ask a question, which I think some of us I know were asking about in regard to the ballots. With early voting and the indecision, do we put the name on? Do we not put the name on? That's, I mean, it seemed like it was very, we were all aware of it this year, but it's in talking with you and discussing it, it happens all the time. And it is up to the individual clerk to make that decision, whether they go ahead with the ballot or not. Reprint, not reprint. But it does happen. And is there any repercussion or what happens? Do we address or what?
So as you stated, those decisions are made at the jurisdictional level. We will generally advise, when I say we, I'll say Marnie, Jordan, our legal department will generally advise election authorities as to what the election code says and how the ballot should be prepared. But in a bottom-up system, the election authorities prepare that final ballot and they work in consultation, we would hope, with their legal counsel, whether it's a state's attorney or some other dedicated legal counsel to make that decision. So if there is an issue with what that ballot looks like, usually the recourse for a candidate would be to go to court at that jurisdictional level and seek some sort of change that way. We at the state board level can't mandate that they change it. We can remind them what a statute says, we can coax them a certain way, but those decisions are made jurisdictionally.
I just kind of wanted to make all of us aware because, it was questioned and we did get calls and I appreciate that.
I think you will see when we present the board meeting calendar and schedule to you in a few items that we are attempting to resolve some of those issues earlier by having our statewide ballot certification meeting occur almost a month before we are statutorily required, with the goal of giving that final resolution to jurisdictions so that it is not a difficult decision. Often they're simply weighing resources. It costs money to redesign, reprint, retest the ballot. So if we can get our certification and any judicial review started sooner, it will build more time in before they are required to print and mail, vote by mail ballots or begin early voting.
And the prioritizing of the candidates as far as the potential for judicial review, meaning the federal first, state, then down to the local. So, I mean, it makes a difference. All right, continue. Thank you, Brett.
Sure. So tomorrow for the primary, SBE staff will be covering, we have an election day hotline, and we also have obviously just phones open to the public and to election authorities. We will begin our coverage from all divisions, running shifts from around 5 a.m. until 11 p.m. or later if needed. Basically, the goal is to be able to handle questions from the public as well as election authorities, and then also outreach from state or federal partners throughout the day. Over the last several weeks, SBE staff have met with different agencies across the state as well. We've met with law enforcement agencies such as ISP and FBI, and state agencies like IEMA and the AG's office, and then also the election authorities themselves. We had a monthly call last Thursday with all the election authorities throughout the state, just to make them aware of the support that we can provide on election day, keep the communication open, and also just work on coordination strategies for the day. So all those plans have been discussed and are in place, and we will see what tomorrow brings. But I think we're fairly confident that we have a good support system in place and good communication plans for the day.
Good. Any questions about that from anyone? Okay.
All right, and the next item then, as I had mentioned, is consideration of the FY27 board meeting schedule. So looking at the board meeting schedule that we have proposed, you will see the regular board meetings are on there, but we also have added some special state officers electoral board meetings. These are the meetings that are necessary and statutorily required during the independent and new party filing cycle. So hopefully these dates will be the only dates that are necessary in order to meet when we need to call the cases, and then also to consider and dispose of any electoral board cases. And as you can see, it is slightly accelerated in the sense that we are trying to do a final ballot certification, especially for any statewide candidates, as you said, or congressional candidates. Congressional candidates often go across different jurisdictions. So if there is a judicial review, that impacts several counties being able to finalize their ballot. So the goal is really to ensure that statewide certification occurs as early as we can have it done. It will depend on the cases that we get. You might still hear from us that we need one additional special meeting, likely in early August, but this is just to set the table for you all and also make you aware of the dates we're going to meet, because it falls over the summer and it is quite often. So at this point, what we are seeking is a motion to approve the schedule as proposed.
It's been moved by Member McCrory. Do I have a second? Seconded by Member Cray. Roll call, Amy.
Ms. Ballard Croft,
Yes.
Ms. Cray?
Yes.
Ms. Genovese?
Yes.
Ms. McCrory?
Yes.
Mr. Brett?
Yes.
Ms. Watson?
Yes.
Vice Chair Turbin?
Yes.
And Chair Donahue?
Yes.
Motion passed.
All right. Bernadette?
Okay. The next item is consideration of a voting system modification request. This is Election Systems and Software, otherwise known as ES&S, voting system 6.5.0.0. On June 23rd, the SBE received, 2025, the SBE received a request from ES&S for consideration to certify the system. On August 19th, the board approved Illinois certification testing to version VVSG 1.0. Erica Christel has provided a memo of the testing that occurred. The testing occurred across different divisions of the State Board of Elections. And following a successful testing campaign, it was concluded that this system does meet all Illinois requirements. Therefore, it is recommended by SBE staff that ES&S be granted a 2-year interim approval of the system.
and staff are seeking a motion for this approval. Erica Christel is available to address any board questions if you have any. There's also representatives from ES&S available via Zoom if there are any questions from the board.
I see them. Do we have questions? Erica is here.
I do have one.
Erica, would you like to come up?
Erica, I just have one question, make sure I'm reading this right. For this system, they are sending the results via the internet from the polling place back to the county clerk or can you tell me about that?
Yeah, the capability of remote transmission is there. The capability for remote transmission is there. I have been told that currently no jurisdictions plan to use that. But we did test the functionality because it was part of the system. So we want to make sure it was secure.
Perfect. I just would make sure that was in the record, that is, so if someone does, because I always like to tell people, there's no internet, there's nothing that does that, but this system does do
Right.
that.
And again, this is through a network and it's only one way. So it's only speaking from the polling location to the central scanning location. So no results can be transmitted back.
Thank you.
There's no problem.
Even though they're connected that way, it can only go one way, but how do we know it can't go the other way?
You can't receive results, it can only transmit results.
Is that only receive results, can't transmit?
You can only receive it, from the polling location, it can only be received to the central scanning location. Transmission can't happen the other way. And they are unofficial results, so none of that is official results.
Okay. Does ES&S have any comment on that?
Yeah, this is Kyle Weber. Is this our regional results product? Is that what this is in reference to?
Yes.
Okay. Yeah, that's a transmission product. It's not straight from the tabulator. It's a separate device that is used to transmit those results, usually a laptop. So it's not even a direct connection to the tabulator itself.
So Kyle, did someone put the numbers into the laptop then to send it? Is that manually loaded in?
No, it's we take the media from the tabulator and it is removed from the tabulator and inserted into the device, which is typically a laptop, and then transmitted via the secure private network in. And as Erica said, I don't believe we have any customers in Illinois even using this configuration.
So you are taking that card out of the tabulator, putting it into the laptop?
Correct.
Are there any other questions or from anyone? Do I have a motion?
Make a motion to get ES&S the 2-year contract that is asked.
Is there a second?
What was the motion?
I made a motion to approve the 2-year request from ES&S to our board.
Been moved by member Turbin. It's been seconded by member McCrory. Roll call, please.
Ms. Ballard Croft?
I have a question. Is it 2 years or is it 2-year interim?
2-year interim.
You want to amend your motion?
Amend my motion to say 2-year interim.
Continue, Amy.
Ms. Ballard Croft?
Thank you.
Yes.
Ms. Cray?
Present.
Ms. Genovese?
Yes.
Ms. McCrory?
Yes.
Mr. Brett?
Yes.
Ms. Watson?
Yes.
Vice Chair Turbin?
Yes.
Chair Donahue?
Yes.
Motion passed.
All right. Next, we have legislative update. Brian?
Yeah, I will invite up to assist with the legislative update. I will just give a general overview of where we're at. Brian will continue to provide the list in the legislative report to you all of election-related statutes. It's not such, potential statutes, legislation. And also wanted to mention that both of our budget hearings now have dates, April 13th and April 30th. So in April, we will go before the House and the Senate for our appropriation hearings. We are listening to other agencies, seeing the questions that they are fielding, and then we'll answer any questions between now and then with staff. Typically, we also do schedule time to meet with the committee members that hear our budget, make that offer, and meet in person to discuss the budget as well. So we will be prepping and reviewing ahead of those meetings. And I'll allow Brian also to overview, because we did meet with legislative subcommittee last week on Friday. So I'll hand it over to Brian for any other relevant update.
Certainly, thank you. I met with legislative subcommittee last week. We discussed a host of bills just for general awareness, nothing that was direct actionable information. Hopefully they shared briefly the contents of that meeting, but just generally happy to answer any questions.
Any questions? I know one concern we've been about protection of our hearing officers when things, is there something happening with that?
So I had a brief conversation following the last board meeting at Member Cray's request and got a more robust understanding of the issue. I'm going to follow up with staff, but it was not contained as part of our legislative agenda. So it will not be something that we're directly working toward, but I will have some hopefully informational pieces in the future on that.
Yeah, because something should be addressed and I think that.
Certainly.
Anything else? All right. Continue. Thank you, Brian.
The remaining items are informational. It's a voter registration activity update, a grant funding update, FY26 fiscal status report, and the 2-year plan of staff activity for the months of March and April.
Do we need anything on any of that?
Informational. If there's any questions, happy to address them. Otherwise, that is it for a short report ahead of a primary.
Hallelujah. All right. Is there any other business? All right. Do we have any comments from the general public? Anything up there, Jennifer?
No public in Chicago.
No public. Okay. Then I would ask for a motion to go into executive session for the purposes of discussing the appointment, employment, compensation, performance, or dismissal of specific employees, pending litigation, and the minutes of the February 18th executive session meeting pursuant to sections 2C1, 2C11, and 2C21 of the Open Meetings Act. So make sure your room is clear up there, Jennifer. If anybody needs a quick break, I'm getting a hint here.
Need the motion.
Oh, sorry.
So moved.
I thought we did that. It's been moved and seconded. Amy, roll call, please.
Ms. Bellercroft?
Yes.
Ms. Gray?
Yes.
Ms. Genovese?
Yes.
Ms. McCrory?
Yes.
Mr. Brett?
Yes.
Ms. Watson?
Yes.
Vice Chair Turbin?
Yes.
And Chair Donahue?
Yes.
Motion passes.
All right. We'll take a quick break.
Do you all control the live stream or do I need to get somebody here to do